Good morning, everyone. It's a great pleasure to welcome you to this webinar on the artificial intelligence organized by the unyer Information Technology and Data Protection team. The artificial intelligence is a topic that it's very dear to us and that involving at very different levels. But at the same time, it's also a complex and transversal topic that require diversified skills. For these reasons, we decided to address this topic by bringing to the table, of course, experienced lawyer, but also business representative, business corporate representative, and technicians who work with this technology on daily basis. In addition, we are noticed that the artificial intelligence can also have a multi-country impacts. This is the reason why, as unyer, we consider useful to illustrate our experience gained in the various countries that unyer is present. Having an international point of view of this topic can represent, of course, an added value for all the participants. I would like to take the chance to remember that unyer is a global advisor founded in 2021 by the leading European law firms, and it's able to provide a multidisciplinary services with a one-stop shop approach. Unfortunately, today we don't have a lot of time, and so I like start to our webinar. But before start, I would like to share with you some housekeeping information. You can submit any question by the Q&A section in the screen, and depending on the time, we respond to the question at the end of the webinar. Otherwise, we give you a feedback by email. In the next few days, we will send the slide by email, and you can see the recording of our webinar on the unyer channel and on our social network. So I think that we can start. Just a give introduction of myself. I'm Mattia Salerno. I speak from Italy, and I am an associate partner of Pirola Penuto Zei, and in particular for the regulatory, compliance, and data protection practice and information technology practices of our firm. So please confirm me that you see my screen. I hope yes. Okay, we can start. As you know, we have been talking about regarding the Act for years, and fortunately, the regulation seems to have reached the end of its journey. In fact, on March 13, the European Parliament approved the final text of the Artificial Intelligence Act. In this slide, you can see all the main passages that I can imagine you know very well, at least. And with the perfect time, we would also like to point out that yesterday evening, the process of linguistic version of the document was completed. The regulation will come in force 20 days after the publication of the official journal, and as you can see, the obligation will then become applicable gradually. In the recent years, everyone has been talking about artificial intelligence. You can just open a newspaper on any day to intercept the topic. And at the same time, the spread of technology as requested to the authority and the government or of the various countries, and also to the international organization to intervene while waiting the European regulation. In the following slide, you will find an indication of the main measures and the guidelines provided by the Italian authority and government and by the most relevant international organization. But in particular, before leaving the floor to Sabine, I would like to give an overview, or a brief overview, of course, on this bill of the Italian government, in which identify inter alia the list of purposes for which artificial intelligence must be tested and used in Italy. It's a very breaking news because our government has published the first bill of this law only the last week. An area of particular interest is the introduction of the artificial intelligence in the tax control, with aim to simplify the procedure for the taxpayer and to improve the efficiency of the tax administration. At least we hope that. In addition, the bill pays particular attention to the use of the AI in the healthcare sector. Substantially, to be pragmatic, the AI in the healthcare sector must be used in the way that must up to healthcare professional the final decision regarding the measure that has to follow in favor of the patients. Regarding the governance aspect, the control activity will be coordinated by the Agency for the Digital Italy and the National Cybersecurity Agency, in order to carry out a coordinated control aimed to ensure the respect of the principle of fairness, transparency, and accountability. Yes, of course, this is, I think, it's a very appreciable initiative, but at the same time, we have to assess how this legislation will be coordinated with the provision of the Artificial Intelligence Act. For the moment, I thank you and will give the floor to Sabine.
Thank you, Mattia. Hello, everybody. I am Sabine Deloge, and I am a partner at FIDAL and works in its digital tech and data practice group. Happy to contribute to this webinar, of course, and I would be the legal speaker for France. So I would like to make a short focus on recent news in France related to AI topics, especially in the field of copyright and personal data protection. So, as you may know, the question of author rights was highly debated in 2023 with the advent of Gen AI products, which are increasingly powerful, and we can produce in a very fast way amazing results in various sectors of creation, like photography, painting, books, video, news. And of course, this situation strongly challenges existing business models and raises key concern about IP for IP right holders. AI tools are trained on copyrighted works in using robots, which are scrapping, crawling all the content made available online and without requesting the prior authorization from the right holders and, of course, without paying royalty fees. Therefore, such learning practices can be considered as such as counterfeited acts. In a nutshell, there are two solutions for the different stakeholders to clear the situation. Option one, use one of the exceptions to the author rights, which is the data mining exception. This is an exception that was created for AI tools. It was first created in France in 2016, actually, and has been reinforced in 2019 with the implementation of the EU directive on author rights within the digital market. And this exception allows providers for free to extract via automatic method data belonging to third party which are made available online. But there are some restrictions to the exception, and notably if right holders reserve the right to use their works in such field. It is called the opt-out right that can be exercised through metadata, through general terms of use of website, or through machine readable process. And in France, end of 2023, 2 collecting societies have exercised this right. This is the SCAM and SESEM. So collecting societies are actually representing authors. They act on behalf of their members who are authors. And they are really major collecting societies because SACEM in France represents most of all music authors. So clearly, the exercise of this opt-out right prevents providers from using music content without clearance of rights. And also some certain unions, or notably for book publishers, also urge their members to provide in their contract with their partners an opt-out right. So it is also worth noting that the French Competition Authority is also scrutinizing the practice implemented by AI tools. Notably, in March 2024, Google was sanctioned, notably on the grounds of for non-compliance of its undertakings with press publishers. But also, what is worth noted, it is that the French Competition Authority has spotted the fact that Google did not warn that its AI system, at that time it was named Bard, its AI system was training on press article without warning press agencies and preventing press agencies from exercising their opt-out right. So this is the situation on author rights. Option 2, the right holders have the possibility to conclude a license with the provider of AI tools, and this is the case for OpenAI, which signed in March 2024 an agreement with the famous French newspaper Le Monde. It is the first one that has been concluded in France. We do not know the terms of this agreement, but I'm pretty sure that OpenAI has encouraged such agreement in consideration of the court proceedings it has faced in the US against New York Times. The last IP topics I would like to mention is that France has registered to the French Parliament in September 2023 a bill to regulate artificial intelligence through copyright. And it creates a new concept of ownership, according to which when a work is created by AI without direct human intervention, the only owners of the rights are the author or assignees of the works that made it possible to conceive the said works. It also implements a collective managing mechanism to collect money for works for which we do not know the origin. And it also provides that a work is generated by AI tools. It is imperative to include the word work generated by AI, as well as the names of the author. I'm not sure this bill will come to an end, but it's really interesting to see how parliaments are sponsoring the IP right holders to defend their IP rights, and this can be somehow to the detriment of innovation. We can go on the next slide, Matt. I would just like to briefly present the CNIL position on the use of AI. It is true that some companies developing AI tools have shown real concern about the incompatibility between GDPR and AI system, both during the learning phase and the production phase. Because how can we ensure the data collected by AI system are relevant, adequate, limited? How we can prevent the generation of false personal data coming from hallucination. And to face these objections, the CNIL has published very recently, in October 2023, the first practical data sheet. There are 7 data sheets in total to provide clarification and concrete recommendation for the development of AI system and the constitution of database used for their training. So I have listed the main topics of this practical sheet. Notably, there is a guideline to determine the legal regime applicable to processing, because it is not only the GDPR. The GDPR is the rules by default, but certain specific texts can also apply depending on the type of data and the purpose pursued, like a police justice directive or national defense. Also guidelines to define a purpose, etc. But also in 2022, there was some publication a checklist, some checklist that was provided for developers to help them to test the maturity of their AI system with regard to the GDPR rules, but also ethical rules. So this guide has very practical approach in the form of a checklist on major topics. So it is really important for developers to know these rules. And in any case, in France, it is really strongly advisable for AI developers to follow the CNIL guidelines, because the CNIL is actually in the running to be appointed as the national supervisory authority to check compliance with future EU Act for AI that will be implemented very, very soon. So we need to be really cautious and mindful of the new rules established by the CNIL on that topic. And I am now leaving the floor to Stephanie and Barbara to talk about AI risk and opportunities.
Thank you, Sabine. So I'm Stephanie Helmich, a partner in IT digitalization and data protection law in Luce's Frankfurt office, and Luce being the German law firm of unyer, and happy to present our German view on this and to provide some groundwork for explaining how the AI Act comes into play and which new obligations are introduced for companies. And just to start with this groundwork, let's have a short look as an introduction at the definition of the terms used, AI systems and models, and as a starting point, building and using large language models, which is one of the most prominent examples or subset of generative AI tools or models which are used to process textual input or natural language program code whatsoever to generate a coding output. And when we look further on how the AI Act will be applied, it is useful from our point of view to differentiate between the various use scenarios, how you could deploy AI models. And the first use scenario is probably just use publicly available AI models, such as ChatGPT, which is available for everybody. Use it in a private cloud within a company infrastructure would be a quite different infrastructure, different approach, or different use scenario requiring other governance measures. The third scenario, which needs to be kept in mind, is train a pre-trained AI model based on company-owned data. And the fourth scenario, which we should look at and see what this requires, is developing even an own AI model or system based on scribed or licensed training data. So all these four scenarios will be handled different. And we will see later on that the AI Act, it's not that easy to see in which scenario you are actually acting under the AI Act. But to start, Barbara will explain what liability regimes will apply. So we are confident what is going on there.
Good morning. Welcome to our webinar from Vienna. Thank you, Stephanie, for handing over to me. My name is Barbara Kucher. I am a partner at KWR, and I am a head of the IT department in our firm. We will look now at the current legal situation and what we can expect in the future regarding liability for using AI systems. As everybody can understand, the use of AI systems can result in damages in various ways. If you think of cases of self-driving cars or medical diagnosis tools, making wrong decision, such output can cause serious impacts on health and life of human beings. A system can make errors in various ways, and in all cases, the question remains who is responsible and who is liable if AI causes damages. The EU Commission has issued two draft directives. One is the AI Liability Directive and a draft amendment for the already existing Product Liability Directive, also called PLD. And the idea behind these new directives is to facilitate claims of damaged parties in future. So in the event of a mistake by an AI system, there are two possible bases for claims. One is there was a duty of care by a human being. The other one is a technical failure. But of course, the technical aspect is always very intransparent, and it's very difficult for a damaged party to evidence that a human being has made an error and that not the technical system has created the damage. And fault-based liability currently presupposes just this wrongful action by a human being. If there is no error by a human being currently, in many member states in the EU, it will be very difficult to pursue a claim against technical errors unless there is a sector-specific regulation or, as we have it already, the Product Liability Directive, but the Product Liability Directive is now 40 years old, and it just does not address anymore the needs of the digital market. So just for example, the Product Liability Directive does not provide measures for damages caused in relation to the loss of data, and it is also heavily discussed if software falls within the definition of a product under this act, or under the directive. Currently, software only is considered as a product if it is attached to like a CD or a tangible product, but an intangible digital product will not fall under the Product Liability Act. And this is going to change. Matthias, please, next slide. Thank you. So what are now the purposes and goals? The European Commission considers the current situation very unsatisfying and uncertain for both sides, for the businesses as well as for damaged parties. The idea is to reduce this legal uncertainty, provide for rules which are uniform in the whole territory of the EU, and clarify current uncertainties. One significant change in the PLD directive will be the explicit inclusion of software in the definition as a product. Under this widened scope, of course, companies, AI service providers, system providers will potentially be liable in future for defective AI systems that are placed on the market. Also, the definition of damage will be extended. Immaterial damage and damage resulting from destruction or loss of data will be eligible for compensation under the PLD in future. The scope of parties, of liable parties, will be extended, and also the strict liability, or maybe just to explain, the PLD provides for a strict liability. There is no need to evidence that there was a fault by putting the product on the market. This will not change. So as well, under the existing PLD and the future, the damaged party only must prove that the damage occurred, the defect in the product, and the causal link between these two. There will not be any fault-based claim. So this will mean the new amendment of the Product Liability Directive will extend the scope of liability for AI systems and software extensively. So this means that companies should already now prepare and consider the risks that their products, when being put on the market, might cause in the future. The implementation will take about 2 years and will probably happen at the end of 2026, which will give companies about 2 years to prepare. The second a new amendment, or not amendment, the second new introduction of a directive will be the AI liability directive. This will be applicable to all non-contractual and fault-based claims. So we have the difference here to the PLD. Here we have fault-based claims for damages caused by AI systems. Another difference to the product liability directive is that the PLD only applies to claims from consumers, but the AI liability directive will also extend to any types of damaged parties, including companies and organizations. Just two major aspects of this new AI liability directive will be a presumption of causality between the fault of a damaging party and the damage caused. If three conditions are fulfilled, so it was long discussed if a reversal of burden of proof shall be regulated, but at the end, the current status is that the burden of proof of the damaged party will be easier, but not reversed. So three conditions have to be fulfilled. One is that the responsible party, the party causing the damage, did not comply with certain EU or national obligations. For example, requirements regarding cybersecurity, transparency, etc. Then the second condition is a reasonable likeliness based on the circumstances of the case that the fault influenced the outcome of the AI, the output of the AI system, and that the output gave rise to the damage. I mean, still, if you consider yourself being a damaged party, it will be very difficult to fulfill these requirements to prove that the company you want to go against with your claim has fulfilled all these conditions. Therefore, a second measure will be introduced, which is an obligation of companies to disclose evidence if they use high-risk AI systems. In this respect, the courts shall have the power to order companies to disclose relevant information, but of course the courts will also have to observe protection of trade secrets and confidential information. And this presumption can always be rebutted by the damager or by the company, but still, if the company does not comply with the order to give out information, there will be a possibility of fines, but also another presumption of causality that the company did not comply with this obligation they should have observed. As already mentioned, this, just one more back, please. Thank you. This will really affect everyone, all parties, all types of damages, and everyone in the supply chain who, of course, would be able to disclose his supplier in order to prevent own liability. It's not clear when this AI liability directive will come into force. It will also have to be transposed into national law within 2 years, but it has not been decided yet. It has not passed through the legislative procedure. So next slide, please. Just to sum up, I just wanted to show you a quick case which did not happen in the EU, but was recently published in February 2024, and it just shows what damage can be caused by an AI chatbot. I mean, this was a relatively simple case where the damages were $650, but imagine if a chatbot gives misleading information in millions of cases, and you're offering your services to a country with class actions. This, of course, will sum up heavily. In this case, you should know Air Canada offers reduced flights if you want to travel to a funeral of a close relative. And Mr. Moffat wanted to attend the funeral of his grandmother and looked at the website when booking the flight, and he interacted with a chatbot. And the chatbot told him, you can get the refund 90 days after the booking. But the chatbot did not tell that the refund must be claimed before the flights are consumed. This information was contained on the website in a special page where everything was explained, but it was clear that the chatbot gave this wrong answer. Interestingly enough, Air Canada tried to argue that the chatbot would be a separate legal entity and that they would not be responsible for the information given by the chatbot. The judge found this quite outrageous and of course did not follow this argument and said that you are of course responsible for all the information which you provide as a company on your website, and if you have misleading or not corresponding information, then it's the liability of the company. I mean, the decision is not really surprising, I would say, and maybe in Austria at this moment you would say they caused an error when concluding the agreement and rather not the damage later, but still just to show that courts are not believing that companies are not liable for their AI used, and that of course this use of AI bears heavy financial risks for companies. Thank you so much. I hand over to Stephanie.
Thank you, Barbara, and I think that is a good good next start into what is required on corporate governance, looking at the AI Act risk-based approach. So it's, I think, easy to understand that the AI Act differentiates between various categories of risk associated with the use of AI systems and AI models. And the great focus, of course, is on the more risk-based systems, starting with a category of prohibited practices, which have a really unacceptable risk for the European Union and the values of the European Union. That includes the development and use of manipulative techniques and social scoring or biometric categorization systems. So that is something where the AI Act says that is really prohibited to use. Then we have the very large and mighty category of high-risk AI systems, which the great bulk of regulations focus on. It is quite complex to define whether a system actually is a high-risk system, because there is a lot of whitelisting, blacklisting, and reverse exceptions. But just to give a brief understanding or feeling what this high-risk category means or includes, for example, safety components in critical infrastructure management, emotion recognition tools and systems, and also tools and AI systems employed or applied for personal recruitment and employee and performance evaluation use cases fall under this category. However, for the last ones, at least, there is a counter exception, which means that you have to look at the specific use case anytime to decide whether there's a manual overruling or decision-making process afterwards, which is very precisely defined and with very many details in the annexes to the AI Act, which allows you to use these even higher risk pre-qualified systems if you have according controls in place. The third category is a category of general purpose AI models, and a further subcategory is the one with models with a systemic risk. So that's the reason why we had a look actually at the very beginning at what is a system, what is a model. So to understand that especially the models with a very high computing power are considered general purpose AI models with systemic risk, which are subject to very high documentation requirements within the AI Act. Then we have a further category of AI systems with a limited risk. These are, for example, human interacting AI systems such as bots or deep fakes, where the AI Act makes certain regulations concerning transparency. And for the remaining category with residual risks, there's and as an overarching basis is the obligation to have code of conduct in place. So this has a very, very brief overview of what is this risk-based approach. And then let's look at how the to whom the AI applies geographically. Of course, we do have two very important roles here: the provider or the developer who has developed the AI system or places it on the European Union market or puts it into service under its own name or trademark. The deployer, which is equivalent to the one using an AI system under its authority, is somebody or a company within a European Union place of establishment or in a European Union-based location, or, and this is some kind of extraterritorial application of the AI Act, it is sufficient to use the output of the AI system in the European Union to become subject to the AI Act. Furthermore, we have all other players like importers, distributors, and product manufacturers who become subject to the AI Act if they place into the market or put into service an AI system together with their product and under their own name. So this is quite complex regulation, how and when you become subject to the AI Act. And just in a nutshell, to look at the very high risk AI systems obligation and maybe the more basic ones, you will see that high risk AI system providers have numerous obligations to comply with training, quality requirements, technical documentations, conformity assessments. They have to implement human supervision and fail-safe integration tools. So a bulk of regulation which explicitly addresses the high-risk AI system providers / developers. And then on the other side, we have the providers or deployers of AI systems in general, where you have certain information requirements, in particular that the system needs to inform you that you are interacting with AI, so with a bot, that you mark output as AI generated, also an obligation of the provider, and the deployer who is using such a tool needs to mark deepfakes as artificially generated, and to mark that in manipulated text on public interest matters with no editorial control has been published, so that you are aware who is talking. And we have, of course, some more general obligations as the overall aim to promote AI literacy in the European Union. and to prevent negative impact of AI systems on vulnerable persons via that code of conduct. So this is just a very, let's say, high-level extract, and it does not yet look at the obligations for general purpose AI models and even the ones with systemic risks. So this is separate and would needs to be added here. But I think it's good just to see what is the most extreme or the most extensive set of obligations which comes with the AI Act, and where is, let's say, the set of obligations which applies to the ones using these systems. And that brings me to how can we deal with governance in this scenario. Firstly, check the scope of application for your company product and services and verify your role. So we will see once the final text of the AI Act is published, that it is very important to verify your role under the AI Act. Are you already a provider, or are you still a deployer of AI systems or general purpose AI models? So that is very important because it defines your risk exposure under the AI Act and the various obligations. Define roles and responsibilities within your company for introducing and monitoring AI systems. Don't expect that everybody is aware of all obligations under the AI Act. Introduce risk management procedures along with data protection impact assessments, which you have to do anyway under the General Data Protection Regulation. Then implement the required transparency and information requirements. And maybe also very important practical advice, adapt your data governance structures for data access within these AI systems. We have seen the various usage scenarios at the beginning. So if you are implementing an AI system within your own corporate infrastructure on a cloud-based basis, you will need to have correct data governance structures to see what data the AI system is accessing and processing. So an easy one, develop employee policies and guidelines to ensure literacy of your employees. So how shall they be aware of one system is going to become a high-risk system if you don't explain it to them? So that is, of course, an easy takeaway here. Educate your employees, and of course, check your warranties.
Thank you, Stephanie. I would like to thank you for the assist. As you already said, the transparency. When we speak about the technology, the transparency, I think, is the most important principle to take in consideration. In particular, because once the activity just illustrate have been carried out, it's very crucial for the company to formalize the rules and the code of conduct in order to be aware the employee about the conduct that has to follow during the use of the artificial intelligence and the technology in general. In our scenario, in particular in the multinational context, at least we are seeing two different approaches, also due to the current use of the technology and the impacts that it currently has on the operation perspective. In particular, in fact, generally speaking, we have two different way to manage the guidelines and the procedure regarding the AI. In particular, we have a group approach and the local approach. The group approach, generally speaking, and in particular the group procedure, define the general rules, the general principle, and an indication of the technology that an employee should use during its activity. But at the same time, the procedures are often implemented at a global level, and the local company are not totally aligned with the use and awareness regarding the use of technology. In some cases, even if the technology is not in place, is not used, or is used for different purposes other than defined in the general procedure, received the global procedure without any integration and without any amendment. In other cases, however, in particular in the company that are decided to approach this topic in a very structured way, we have, yes, of course, the group guideline that define, as we already said, the general principle to follow, but we have also a local guideline that should be represent an annex or an integration of the group guidelines. And in these cases, we have to specify the rules of the use of the AI tools in the local context. Of course, taking consideration the effective activity carried out by the local company. It's important to underline that in a group, each company shall carry out different activity, but in particular, taking consideration which are the local requirements. In particular, I mean the privacy aspect, the privacy matters and the labor relation matter. We take in consideration, for example, in Italy, we have a specific guideline by Data Protection Authority to take in consideration in the use of the AI in the healthcare sector. But at the same time, if the use or deploy of the artificial intelligence in the company shall have an impact on the operational activity or in particular on employment, we can take in consideration the opportunity to involve the trade union just to verify the impact of the artificial intelligence on the employment situation. So just before to give to leave the floor to Sabine, our general recommendation regarding the approach that company has to follow regarding the procedure that has to implement for the use of the artificial intelligence, but for the technology in general, at this stage, the first one is necessary to regulate the method of use of the system. At the same time, please critically review this document in accordance with your effective activity, effective use of your technology, and applicable law. Because if you decide to implement a procedure just to say that you have in place a procedure, is not a right approach regarding the use of the artificial intelligence. Also take in consideration the risk that the use of this kind of technology can comport for the employee, for the user, and for the organization in general. For the moment, thank you, and I leave the floor to Sabine.
So, as I said, these practical tips can be used in addition with those you have previously recommended, you, Mattia, and also the one mentioned by Stephanie. So for all stakeholders, the general recommendation would, of course, be to adopt a compliance privacy approach at every step of the development or deployment of AI tools, and in taking into consideration the various rules that apply. As you have seen, this is a complex environment and a very, very complex one, actually. And this approach should be based on the setting of a roadmap to implement compliance measures that will be adapted according to the legal qualification determined by the different stakeholders and the level of risk identified. And this also involves closely monitoring the adoption of text at local, European, and global level, but also to follow closely the recommendation from administrative authorities, the codes of best practice published by professionals, and so on. Especially for deployers and users, so Mattia mentioned the setting of guidelines at corporate level, at group level, or local level, and I would like to mention that the practical tips can cover various use cases inside companies which are working with AI tools, notably salespeople who are writing emailing campaign with ChatGPT, or legal people, as you mentioned in the introduction, who translate an agreement with DeepL, communication team who is illustrating the company website with DALL-E or Midjourney, and developers also who use a tool generating codes like Copilot. It is really important to disseminate information internally about the best practice to adopt, but also to keep on monitoring AI tools used in-house and train staff to write prompts. This can be made through various actions, such as inform the staff about the risk linked to the use of AI tools, such as IP risk, business security, risk of discrimination. It should be also to list the type of tool or practice allowed in-house, and also listing precautionary measures to be followed, such as disabling prompt history, not to transmit confidential or personal data information in a GenAI tools, and rather use neutral, anonymous information in prompts. And also, we should make sure that the final results that will be generated by the AI tools can be used without legal issues. So the recommendation would be to encourage employees to document as much as possible the creation process, notably recording the AI results with edits, without edits, and with successive edits. And also to make sure that the final results to be reused can have certain original contribution made by the employees. Other tips to be followed is to always double check, reread, challenge, assess, reappropriate the final results before using them. This is a critical approach mentioned by Mattia previously. And always obtain internal validation, preferably by your legal service, before distributing AI results externally, notably to check the absence of violation of third-party rights in the final results, and also to check the terms of use of the AI system, whether it provides for an effective warranty and whether it permits to reuse generated content. And of course, the last guideline would be to inform the public of the use of AI when we provide final results to them. For next slide, I focus rather on what practical tips should be followed by developers and providers. The first one, in my view, is to conduct a risk assessment of the AI system to determine the legal rules applicable, and also to put the risk into perspective with the expected use of AI. And to make this step will allow, to make this assessment will permit to the company to prepare a clear documentation for user, to specify the intended use and the potential risk and the condition for exemption of liability. Also, it should be good also to organize the protection of AI system. There are no specific rules applicable to them, so we should refer to existing regimes such as IP protection of software. Algorithm is a software, and so we can benefit from an exclusive right of exploitation on the algorithm, with exception of interoperability, backup copies, text mining, etc. The other options to protect AI system would be to refer to the rules applicable to database. It is in France, it is a sui generis protection when a person has made substantial investments in the construction and the structure of the database, and this right allows to prohibit the extraction of substantial part of the database. But we should keep in mind that the protection with database rules that not apply to AI system as such, but rather to the database which is used to teach and train the system. And of course, we can also have the protection with business secrecy or the implementation of contractual solution which would provide for a sufficient protection. And in respect of bare metal data, developers should also follow the methodology proposed by the local data protection authority, and this will help them to document the training data used for AI, and developer would also have to ensure that individuals are properly informed of the processing of their personal data and of the existence of their data protection rights. And for IA contracts, so contracts signed between developers / providers and customers, the tips are actually the ones, the mix of the practical tips I have previously presented. On IP aspects, notably, it is really important to determine the ownership and licensing right of the AI product. Is the customer the owner of the final results, or can he only have a right to use it? And if so, under which circumstances, which condition, exclusive, non-exclusive, commercial, non-commercial use, etc., etc. On data aspect, so whether the data are personal or not personal, we should clearly clarify who is the owner of the data, how it can be reused and by who. For personal data, it is necessary to define how it will be collected, stored, and used to meet GDPR requirement. And to streamline the process, developer will have also, again, as I say, the possibility to work by reference to the CNIL recommendation, guidelines, and checklist. And of course, in the negotiation, the provider should ensure that it has all rights to use training data and that it complies with data protection law. And on customer side, and for input data, customers should be the one responsible for data protection compliance. The other sensitive clause would relate to risk and liability. It is essential to determine liability rules. This should be clearly settled. Who is responsible of the AI generated product when it causes harm or damages? So provider for sure will ask customer to use AI system with appropriate human oversight to use it responsibly and ethically. And on customer side, he will be asked to provide, he will ask provider to comply or to assist with legal obligation and to comply with good practice and to ensure transparency. As for the results generated, we should outline what level of accuracy, reliability, and efficiency can be expected from AI-generated result. And finally, all the documentation, because there is also an accountability approach in the AI Act, as it is existing for GDPR, provider must have clear and complete documentation, and customer must always have an access to data and can ask for an audit. And this should be clearly provided on the contract. So as I said, we arrived at the end of the presentation of the main legal topics to be considered for AI tools. And for the next part, I'm happy to hand over to our external speaker, Gabriel Scafati, and thereafter Christophe Boswein and Antoine Bulle. So Gabriel, it's up to you.
Hi everybody, can you hear me? Okay, perfect. Thank you very much, first of all, for inviting me to this such valuable panel. And I will try to be quite quick and to not boring to death. So I am happy, first of all, also to having seen that a lot of points that you mentioned in your presentation today are perfectly aligned with our approach. I refer specifically to what I have seen about the guidelines and procedure of on group versus a local approach. That is something that is really impacting and fit with our approach. And I also have to say at preliminary level that it is fair enough to say that AI was not born as a lot of people seems to think on November 22 with GPT and generative AI or LLM or general purpose AI system, as we would like to call it, but is something that is does exist since a lot of years. And so also in Sky we are dealing with these matters for years. But it is important to distinguish in somehow the normal, let's say, AI from the Gen AI specific tool. Speaking about the AI, we have in place a lot of different procedure, both under legal and specifically data protection perspective and cybersecurity, CTO, etc. area and function. Obviously, not always the AI system could impact, involve, and process effectively PII, so personal data, but where AI system do process and involve the processing of personal data, we apply all our procedure that normally have in place. Effectively, as I said, speaking about the Gen AI, at group level, we decided to design an ad hoc procedure and ad hoc governance policy for a lot of reasons. First of all, it's obvious that Gen AI tool include some by design risk, let's say, and specifically impacting on some companies like Sky that use a lot of a huge quantity of images, video footage, also covered by IP, copyright, etc. So the possibility that the business function and Sky people use some Gen AI tool without any awareness is really slippery and risky. So, as I said, we implemented it's some month ago. It's quite recent, and we are just escalating, experimenting this procedure in this very last month. An ad hoc procedure on Gen AI that, as per the title of my presentation, results in mapping, training, and monitoring, or mapping, monitoring, and training the use cases. In practice, what we have thought and foreseen, we put in place and created an ad hoc channel that mainly works via a ad hoc email address that is Gen AI Working Group. So very clear, idiot-proof. Gen AI Working Group and behind this address respond all the top management from UK, both under CTO and so information technology area, and legal tech and data protection function. So then at the cascading level, in all these three main functions, so legal tech, data protection, and CTO, cybersecurity, the information and the ticket, let's say, that is opened by our business is cascaded in all the countries and subsidiaries impacted. Let's say that this led to a very deep and pervasive assessment, both under, as I say, data protection, cybersecurity, and legal level. So all the use cases that are presented and asked to this specific channel for GenAI are evaluated, assessed, and then you can have a green light or red light or orange light, depends. But in the most cases, what is the result of this opening of the ticket is dealing with the very vertical meeting with all the sometimes separated, sometimes at choral way. There are a lot of meetings to assess specifically the data protection or cybersecurity or legal aspect with all the countries impacted, and if needed, and a lot of time is needed, with the function of the vendor, of the supplier that is involved and is to be assessed in the context of the negotiation of a POC or an agreement, something like that. So after having mapped by design and so preliminarily all the use cases, and so after the having once validated and approved the cross group these use cases, we of course have to map the ongoing working of this use case in de facto, so at practical level. So we have seen just the monitoring and the mapping. The third point, that is the training, is one of a point of which I particularly care about, mainly because I think, this is my view, my opinion, is one of many of the principle and points that could link and liaise and match GDPR and the AI Act regulation. We know that there are they have in common principle like the risk-based approach, the accountability, a very important spotlight on all the breaches, data breaches issue, the vulnerability assessment, the robustness of the technical measure to defend the AI tool. If we are speaking about AI, this is something that is also mentioned in the very valuable and important so-called guidelines on trustworthy AI of the high-level expert. The robustness and the importance given to the all the cybersecurity aspect. And another one that is sometimes not really reminded as it worth, I think, is the human mistake. So we know that all the data protection aspect and so the GDPR principle are really involving humans, the people. We know that the data breaches causes are mainly due to the human mistake before then all the technical implementation capability, etc. So it's really important to train people, and of course using something catchy like the GenAI tool is most of all very important, because an example I like to do when I speak with my colleagues or during training, etc., is that the easiness of the use, the apparent and alleged easiness of the use of the GenAI tool does not correspond at all in most cases to an equally easy and transparent easiness and transparent backend operation of the machine. So most people could think that it's very easy and with no consequences to put to feed up the machine, not the machine learning, but to de facto feed up the Gen AI tool, giving prompt and input to the ChatGPT or ChatGPT-like tool. But this is not the case at all, as we know. So if we are speaking about all the creativity of some very famous TV series of Sky, specifically Sky Italy, like Gomorrah, etc. If you give to the machine, to the ChatGPT or DALL-E or something producing images and picture, you give the picture with the Sky logo and brand of two guys shooting on the beach with guns, and someone is interrogating the same tool all around the world and ask, please, ChatGPT, give me an image, a picture of someone shooting on the beach. The risk of having an output similar, because also the similarity, that is a concept contained in the terms and conditions of most of these player is curious, but the risk to have some output similar, containing piece of your creativity is high. This is just one catchy example about the risk, but obviously there are many other risks also under data protection perspective, obviously, that are to be considered. And so, yeah, I repeat that training is one of the most important points to be highlighted in using the Gen AI tool or the technology tool in general. Yeah, so I think having concluded, and I can let the floor to the next speaker.
Thank you very much for having me today, talking about CrowdStrike's AI governance. In this respect, I think Gabriele mentioned a very important point, that AI is nothing that has been invented in the end of 2022, but it's something that we deal with for 2012, and we are dealing with AI since the very beginning. The reason for that is that cybersecurity in particular requires very fast, not human-driven, but machine-automated decisions, which you can see here on the slide. This is our AI journey since has been established. Yeah, and it is something that is where we have critical milestones overall where we started that. In this respect, I think it is most important with respect to the new AI Act we are now talking about to get clear what AI is. Yeah, so when you take a look at some of the milestones that you can see here, I would not agree that this is actually treated under the AI Act as AI. Yeah, so always keep in mind what really AI is, or explore what AI is. Yeah, in particular in the field of machine learning, where what has been invented with the starting of the IT itself. So that we are using computers. So it is something that has been used in the 80s and has been developed further and then correlated. Yeah, and first when it's correlated, then machine learning is actually, or in my view, can be treated as AI perfectly. Yeah. In this respect, we also heard about Gen AI to a large extent. So this is something that also CrowdStrike takes very critical in this respect, because in the end, AI and Gen AI will enable us to move faster. Yeah. What I showed you at the very beginning is adversaries are moving faster. This requires from security operation teams that they are super fast. Yeah, that they have process automation in place, that they can use the chat function, asking the machine questions. Show me this. Have you seen this malicious code anywhere? To what adversary does it fit, and so on. So these are actually the beauty and the benefits that in Gen AI can provide. when we talk about Gen AI, most of you potentially think about ChatGPT. Yeah, so I want to encourage you to open your mind in that respect. So Gen AI can be much more. Yeah, and to what also the other co-speakers provided before. Yeah, so we always need to take into account and review what kind of risk level is involved in that. When we talk here about Gen AI in the cybersecurity space, enabling people to find quicker malicious content and who maybe is behind an attack, you probably or hopefully will agree with me that this is something that is not high risk. But AI itself is not a self-running system. Yeah, this is something that that must be trained over years, validated, tested, and so on. And with respect to AI government, also back to my co-speakers' points before, I think most important is to know what you manage, yeah, how you and where you feed your system. In this respect, I think it is majorly important, and here I think we have some great learnings from the implementation and our maturity curve from the GDPR. So we are also, with respect to AI, not reinventing the wheel. Yeah, I think what the major points that the GDPR taught us, and they are relevant to AI as well, are you need to know what you manage. Yeah, only what you know or what you can measure you can manage. This is also something that applies here. In this respect, I think also what with the experience we made with register of processing activities and things like that, making things transparent is a major step on your journey to get your arms around managing and reviewing AI. Yeah, only if your teams in your organization know who to go to obtain advice and maybe also receive a sanity check on something, on a new invention where it's maybe not clear if it's a regulated AI, yeah, because not all technical invention, I promise you, will be treated as an AI under the new regulation. So to that end, it will be super critical to always think about that. Then it's important, also a learning from the GDPR, not to think in silos. Yeah, this is the major point I would like to make here. Yeah, so this field that you see in the middle, accuracy, it is perfectly necessary for quality. Yeah, and AI will only be good if you have a high accuracy and a high quality in your AI. Yeah, but also, and this is something that taught us Anne Kavukian's privacy by design approach, that you also need to take into account other categories when designing and managing AI. On the one hand, you see safety. Yeah, safety is our business. Data protection is our business as a cybersecurity company. So safety is something that is super critical in that space. Yeah, it also relates to some aspect to accuracy because data can be manipulated. Yeah, so for this reason, you also should always be very critical in challenging where is this information from. Yeah, and particularly if you have third sources information, then you need to be very critical and deeply and accurately reviewing this information before you can use it. If you have internal resources where you know pretty well what it's used, then other challenges can appear, and these are back to the privacy bucket that we have seen the slide before. In this respect, I also want to bring up a major point that is super important to us as CrowdStrike, yeah, because we learned very early in our AI journey that we need to take into account the privacy rights of our customers. In this respect, it was super critical for us, yeah, to find ways how to remove personal identifiers from data sets that are fed to our systems in that space. Yeah, so from a privacy by design perspective, I can share with you that it's super critical not only establishing but also maintaining a super relationship to your engineering teams, that they also are open. Yeah, often you, or maybe yourself, you made this experience in the past. I have 15 years of experience in this privacy space, and I learned too often that people come too late to me. Yeah, this journey of AI also requires that people right from the beginning approach you and explain to you, sanity check with you, walk you through what is going on, that you can help them. You all do that for the great benefit of bringing your organization ahead, and this is what people need to understand. What you have seen on this last slide that I wanted to show you, back to this Gen AI example I made to you, yeah, this nice sentence that you see here on the bottom, 8 hours work in 7 minutes. This is our goal and why in the end we want to apply AI for what we are doing and how we are doing. Yeah, so this is something, and for us as Europeans, I think super critical to understand. Don't be too protective against AI. This is also what the regulator or the politicians emphasized in this entire process again and again. We need to be open to AI. So to this end, if I can express one wish at a final stage of my presentation here, it is also expressed to our regulators out there, that they become open and they help organizations to get things ready and enable them instead of preventing. Thirdly, everything what you have seen on my previous slide, it must come with safety and privacy. But this is something that is a design process that must be provided, where we also as information security and privacy practitioners can super helpful with why I believe it is super set with our teams in this context. Thank you.
Thank you very much. I'm Antoine, CTO at DH. So DH is an engineering company working in the hospitality tech field, and have been working with AI since 2016, working with the very first machine learning model, trying to implement that in our products. And now we are in the middle of a very big wave, what I see as a very big wave, transforming wave of AI in a company like DH, which first activity is engineering, developing platforms. And here you have an example of how powerful and big is this wave. And with this example of ChatGPT getting in 2 months, reaching the line of 100 million users, which is something that was not seen before in the different tech transformation we had the past years, and especially social networks, etc., etc. So I think that this transforming wave, as you will see, has a multiple impact in a company like DH, in multiple departments, in the way we work on a daily basis, and it's really transforming it. Now the question is how to take benefit from it and to be more competitive, but also how to manage the risk, which is for me very important. So to give you an overview of what we're doing on the next slide. So DH is a tech company working in the hospitality. We're providing a platform for hotel distribution. We're working with 17,000 hotels around the world. And to give you an idea of the volume of data, we have processed for our clients 100 million bookings in 2023, and we're operated in many different countries. And AI at DH has in the daily usage an impact in very different fields. For example, obviously in our products. So we're providing, for example, analytics on the distribution of hotels and be able to create forecasts of what's going to happen in terms of demand in the hotels, how we could optimize pricing, optimize the forecast the cancellations, for example. That's the kind of topic we're working on, along with what is very impactful right now, and I'm gonna focus on that, the Gen AI tools, providing the ability to assist many employees in various different tasks. And one that is at the core of what we do is engineering, developing software. And I will give you example and trying to make you understand how impactful Gen AI is for the engineering work today. And obviously for office software, we talked about the what was Bard, which is now Gemini at Google, and Copilot at Microsoft, that will transform a lot the way we do this kind of webinar with automatic summaries, with live translations, all this kind of thing. And you will see this kind of tool arrive in the very next years. So to focus on one example of engineering, I try to give you a very simple example that is with Excel, a very useful tool that you probably use every day for some of you. So here, a very simple exercise. You have dates in Excel, and you want to define in a new cell what is the Monday of a month that is corresponds to a date that you have in a column. So that's an exercise that may look simple. And actually, as you can see on the right, that's the real formula to get that. So that's not so simple at all. And if you see how I can solve it with ChatGPT, for example, here, it's super impressive, meaning that I have a very simple prompt, one sentence on the top. It wants to write a formula to provide the first Monday of the month of a given cell. Please explain to me how do you do that? And not only ChatGPT is providing the formula, but also all of the explanations very well structured on how to do that. And that probably would save for somebody who is quite efficient with Excel, probably a lot of minutes to do this kind of simple operations. Now, let's say that you need to do that, but more complicated on the next slide. You need to include the fact that Monday may be a bank holiday. So if Monday is a bank holiday, I want to have the next Monday that is a working day. Now it's more complicated and would take probably something between 30 minutes to an hour for somebody to do that in Excel. Here you have in one sentence again a question to ChatGPT, the full explanation and what you need to do with the formula. That is quite more more complicated this time, but very well explained. And that's really an example of what you can do in this kind of task, which is not engineering. So when you transport this kind of operation to engineering, that's the next slide, you can see that as an engineer, my job is to write code. So you have this example of in the next slide with the Copilot, where you have you need to write code, and what you can see with Copilot is that you can quite easily write a few lines and have Copilot completing the whole function in this example. On the next slide, sorry, I think we're quite stuck. Thank you very much. The whole function is completed by Copilot, which is probably saving now a lot of minutes in a daily work. And when you do that all day long, that's a very, very efficient tool to increase productivity and to make the work of the engineering not only easier, but also different, meaning that it doesn't mean that this code that is generated is 100% valid and reliable, and that's the right one. So it would require rework. And that's where you need to be super aware of the kind of risk you may have with Gen AI and learn how to use it. Because obviously there are very important risks that you need to know. And that's the next slide. Thank you very much. And the risks, and we have to know it. And that's also why this very important guidelines need to be defined, and that's we need to take measures to manage all this. Obviously there is the question of confidentiality, which is more or less the same as the question of confidentiality we have with all of the different tools we use. For example, here we are using Microsoft Teams. It means that all of the video streams and slides, etc., are transferred through Microsoft servers, and you need to know where they are located, who can see it, with what level of encryption it's processed, etc., etc. But that's still corporate information. But what is a little bit new with AI is the fact that they are based on models that are trained on a very big set of data. In case of LLMs, that's incredibly big set of text that is processed to create large language models. So that's very important. Why? Because somewhere this data are included in this LLM content. And to give you an example that may illustrate the legal work, there is this example of 2023 last year of a lawyer in the US who provides references to cases that never exists. And that's where the reliability in Gen AI is a little bit different from what we've seen before, is that reliability errors may be quite different. An error in AI may be an hallucination. An hallucination is and can be very complete, precise example that can be very, very credible, but totally made up. Meaning that in this example before, there were cases that never exist, but if you don't know it, if you have not checked that they exist or not, you can be really mistaken. And for all of the different fields, when you generate AI, it may happen. In this example, you can also in ChatGPT, that was an early stage of ChatGPT, get access to training data. That's a prompt injection, a way of hacking the chatbots. So that typically the kind of thing that we can see as well in AI. And you can and you have to know that there is a kind of technical war between people and experts, hackers, but also researchers trying to hack chatbots, and all of the companies providing the best ones trying to protect them from this kind of attacks. For example, here prompt injection. Now, if we want to now reorganize and see how we could manage these tools and define the guidelines in a company like DH. First thing is for us, for all of the different teams, apart from the AI we include in our products, is to choose the kind of tools we will provide to the different teams in the company. Because one of the problems is obviously that we cannot prevent anyone from using the ChatGPT free or even paid version without any authorization. And because it's a very powerful tool and it can provide and accelerate, improve the productivity of each one of us. So that's why it's very important to provide tools. What we look at when we select the tools we want to work with, it's obviously the performance, and there are very interesting leaderboards in ratings around that. Also, that's for us critically important, where data are processed, the data that we provide to these AI tools. Are they used to train the models? And the corporate guidelines is data are not used to train the model we used and the different tools we validate internally. And data must be processed as much as possible. And that's why we're currently changing the tools we're using in Europe. Because we want all of this processing and the way it's stored and processed to be within Europe and within the legal constraints and regulation that are defined in Europe. That's part of the sovereignty approach that is quite important for us. And also, we need to remind to all of users, if it's new tools, that's okay, but they have to keep in mind that they're still responsible for all of the generated content. And to do that, that's critical, and it was said before by Sabine, but it's very important, training employees, explaining to them both the power of Gen AI, what they can use, what they can get with all this kind of tools that we provide, but also that confidentiality, responsibility is important, and that there are ways to use them. You can learn to write the right prompts to get the right results. You can learn to use Copilot to have efficient and relevant results. So that's also very important. And so to conclude, I would say that first, it's, and I really would like to focus on that, that's a very big transformation that is in progress. We're talking about the journey through AI. That's extremely important, extremely impactful, and with a super high potential. The complexity is that it's very quickly evolving. New tools are released more or less every month. They, as obviously we can see, the regulations are evolving and quite quickly currently. So we need to stay up to date. We need to, with webinar like this one, we need to follow the technical progress. And I give you an example of very good newsletter, superhuman.ai around that, and iterate on this process as it's progressing quite well. And to illustrate all this, you've seen that these pictures were all generated by OpenAI DALL-E. I'll let you define who owns the intellectual property of this image. I think that's a good question after the explanation we had before. Thank you very much, and I leave the floor to Mattia for the conclusion.
Thank you so much, Antoine. Very very nice, very interesting speech. So I see that we have a lot. We have a very different question, but considering the timing available, I think that is better. Is a very pragmatic solution to provide a feedback by email to the different participants. So we have come to the end of our webinar. It was a very pleasure for us to host to our speech. I really thanks to the unyer colleagues for their speech. Really grateful for the external speaker for their practical experience and arguments. So just lastly, quick information. We will send to all the participants the slide by email, and the recording of our webinar will be published on unyer digital channels. But in any case, all the details about our contact we will send by email. Please stay up to date on our next webinar and visiting our unyer.com website, and see you for the next event of the unyer IT and data protection team. Thanks to all again, and have a nice day.